Now that we are officially at 9 o'clock, let me introduce myself. I'm Judge Jim Edwards. Also on the panel are Judge Eric Eisnagel and Judge Meredith Sasso. We are here for an oral argument session of the 5th District Court of Appeal. Our first case is number 2981, Richard Moore versus Sally Moore. And we will presume that appellant wants 5 minutes for rebuttal unless he tells me otherwise. And with that, you have the floor.
Thank you, Judge Edwards. Mike Brownlee here on behalf of the appellant, Richard Moore, and I would indeed like 5 minutes for rebuttal, please. As your honors know, we raised a number of issues on appeal, but from our perspective, the big ticket item is our Latches defense, and the one that we'd like to spend the most time on in the oral argument. I always thought Latches was like the Yeti or Bigfoot. It was like something you heard about, but you would never really have an opportunity to see or argue. But here we are, and I think this is like a textbook case of Latches, in my opinion. We've got a 4-part test in Florida for Latches. The first is that the defendant, in this case, Mr. Moore, does something that the opposition claims incurs some sort of liability, which here is obviously the failure to do certain things under this 2003 marital settlement agreement turn final judgment. The second prong is that the plaintiff, in this case, Ms. Moore, had knowledge of the defendant's conduct, and despite that knowledge and an opportunity to file suit or to press her rights, elected not to do so. Here, the record is replete with evidence that Ms. Moore knew the entire time she could go to press her rights in court and simply elected not to. You can look to trial transcript page 162 for that testimony.
Can you clarify on our standard of review on this issue? I think you've argued it's a de novo standard of review.
I did, Your Honor, and I should probably retract that. I think that I fell in love with a quote from that Thalloy case. And I think if you look at, as opposing counsel ably pointed out, I think there they were really looking at the sufficiency of the defense itself. So to the extent that's a question, I think that should be reviewed de novo. But in terms of whether or not the court correctly found that there was not evidence in support of the Latches defense, that should be reviewed for competent substantial evidence.
Okay, so under that framework, why is the evidence here that's been presented not enough to serve as competent substantial evidence?
Well, because there's an overabundance of record evidence in this case that the former wife knew of her right to go to press her rights and failed to do so. And there was never, at least as far as I can see, any explanation given other than this idea that former husband misrepresented his financial status, which is something I'd like to get into later. And in my opinion is 100% not a fair excusal of her rationale for not going to press her rights.
But counsel, isn't that an important part of the Latches issue? I mean, if you're arguing Latches, shouldn't you get in and address that issue now instead of later?
I'm sorry, Judge Eisnagel, could you say that again?
You said the Latches issue is the most important one for you. Is unclean hands an element of that? Does your client have to have clean hands to?
100%, yes.
Okay. Well, so if your client misrepresented his financial status, why don't you address that and the issue of unclean hands?
Okay. My client, first of all, there was no finding that my client misrepresented his financial status. The only evidence that was cited and that's anywhere in the record is that he made a decent amount of money from, let's see, I think the main time frame was 2004 to 2009. And let's unpack that really quickly because the math is important here. Okay. It is, let's see, excuse me, give me 1 second because I've got the math worked out here. Oh, sorry.
1.7?
Yeah, so it's 1.7 from 2004 to 2009. So that's 6 years. Okay. And that's gross income. That's very important. This is not net, that's gross. That's $287,315 per year in gross. If you subtract out the alimony payments he was paying each year, which was $27,900, that's the $2,325 per year. That gets us down to $259,415.67 per year, again, in gross. That doesn't account for tax payments. This Mr. Moore was living in Japan or Korea, depending on the year.
He wasn't running a business though, right? So when you say gross, I mean, what other than taxes, what else would come out of that? And business expenses wouldn't come out of that amount, right?
Certainly not. I'm talking about, cost of living. I mean, food, electricity, whatever he's paying. He has a second family. At this point, he's remarried. He has a child that he's supporting.
So what did he make net then during that period?
We don't know. I mean, there was no evidence besides his most recent financial affidavit, which doesn't speak to that time period. And that's why I think the unclean hands argument or defense, if you even want to call it that, because if you do a control F in the trial transcript, the words unclean hands are not even uttered. It was not raised at least as I recall, it was not raised in avoidance as a reply to the Latches affirmative defense. I mean, there's just not a finding of that.
I guess, counsel, the problem is your, gross or net, those numbers are pretty large. And why isn't there an inference that your client was making at least a decent amount of money at the same time he was representing that he was in financial sort of disaster?
Well, we also know that he had something to I think a $92,000 tax bill in 2009 from the IRS that former wife agreed that was a liability he incurred. It took him 2 years to pay off. And Your Honor, he has right now in the supplemental final judgment, he has a net worth of $215,000 to $230,000. He has a house in Missouri and he has 2 lots in Ocala worth $8,000 total. This is not a man who is hiding money somewhere. I don't know. Perhaps he was, like many Americans, maybe he did not manage his money as well as he could have. But it's undisputed.
Counsel, I understand, and I'm not saying that there wasn't evidence that could have been presented, but all this panel can do is go on the evidence that was presented. And the evidence that was presented was gross or not. I understand what you're saying. I get your argument, but those are large numbers. And if that's the only evidence that was presented, why is there not a permissible inference that your client was on some level misrepresenting his financial status?
Because it doesn't seem to me that this is the time for inferences. The court never made that finding.
Well, isn't there a difference between an inference and a finding?
Yes, certainly. But I think in the same, yeah. Yes.
I get that the trial court didn't make a specific finding in that regard, but we're talking about whether there was competent substantial evidence, right? Is your argument that there had to be a finding and that the lack of a finding is reversible?
I think to the extent that the court thinks that their appellate review is hampered by the absence of a finding, then I suppose that there should be a remand for a finding. I don't think in this case there needs to be further review. I don't think there's evidence that he misrepresented his income. He's taking loans out from the former wife, which he paid back. We know he had a $100,000 IRS bill. I think if the trial court who heard all this testimony was inclined to believe that he truly misrepresented his financial status, she definitely would have said so. She didn't. So I think for this court to say, okay, he must have been lying, or in the words of my brother, engaged in trickery and deceit, I think that certainly would have appeared somewhere in the many pages that were issued from the trial court. And in the supplemental final judgment, it's important to note, he is relieved of his alimony obligation. There are findings about his net worth. These are not the type of findings that you find when a judge feels someone's hiding the ball and messing around with the amount of money that they're truly making.
Counsel, you're talking about 2 different time frames. You're talking about now, after he's retired, the judge finds that he doesn't have the ability to pay alimony and that the former wife doesn't have need for alimony. That's different than you're saying, well, she waived her right to the VIP account. She waived her right to variable alimony when in fact he did misrepresent to her that he was poor and broke and had no money. He made a misrepresentation further, didn't he, that the IRS had actually levied on the VIP account. I mean, it's not just he shaded a little bit on his income. The alimony was based on 32% of his gross income, which at the time was around what, 82,000, maybe 87,000. And he was making 3, 4, 5 times that amount when he was crying poor mouth to the wife, wasn't he?
I mean, yeah, I don't know that those numbers are as borne out as specifically you're saying. I do know that, yes, he was making that the original 2,325 amount was based on his $87,000 base pay. It's also a little bit unclear how he was compensated with bonuses and everything else. What I do know is that all she had to do in that 2003 MSA was file a quadro, and all of these problems, lo these 17 years later, would have been taken care of and satisfied. And now, as a result of her inaction, an IDO, the original income deduction order, puts the onus on her.
How is your client prejudiced, though? I mean, it's kind of like the kid who kills his parents and then cries, "Poor me, because I'm an orphan." I mean, your client successfully didn't pay money for years and years, and now he's been forced to pay what he's owed. I mean, where's the prejudice?
The prejudice is in that if former wife had done what people are supposed to do under the doctrine of Latches, which is go and press their rights, and this notion that she he did know and was lied to, she is questioning. The record is full of email questioning to him about about his financial status and her suspicions of his status. In 2010, she filed a contempt motion. She's represented by counsel. He voluntarily attends a deposition where they have full documentation of his income, and nothing further happens for another 7 years. So this notion
at the same time, though, isn't he telling her he's broke? He doesn't have any money. Please don't come after me. Please, can't I stop paying alimony?
Yes, but I think that if it is as clear cut as he is simply lying, as my opposing counsel has said, and as the court seems to be inferring, even though the trial court did not make that finding, I think that would have been something that, able counsel in 2010 would have pressed with full access to his financial documents, as would the former wife.
So maybe you're talking about the lawyering wasn't good. You're not talking about she should have known how to do a quadro, or she should have been able to investigate and so forth. I mean,
the quadro is very, very clearly laid out in the
counsel. Did your client misrepresent? As Judge Edwards was saying earlier, I had forgotten about that in the record. Do you agree that your client misrepresented the tax levy on the VIP account?
Your Honor, I honestly do not remember what I know that he used the VIP account to pay off the IRS bill.
Yeah, but didn't he represent? Didn't he represent to the appellee that the IRS had actually levied on the account, like forcefully came in and took the money?
Judge Einstein, I simply do not remember, and I'm not saying that to be evasive.
If he did, wouldn't that be a fraudulent representation?
Well, I think she has access to all of the documentation. Yes, it would. That would be a fraudulent misrepresentation. That if that wasn't in fact, yes, that would be a lie if it's a lie, right?
Going back to just the initial elements of Latches, unclean hands aside, and whether there's competent substantial evidence to support finding that there was not prejudice. There's evidence or inference you can reach in the record that he used this $172,000 in extra alimony, and I recognize that number is disputed, to pay down his mortgage on his house, the VIP account to satisfy a tax bill. He also chose not to move for modification at that point and just hope that wife never enforced her rights under the agreement. When we think about it in terms of the very rare remedy of a Latches and equitable proceeding, why is that not competent substantial evidence of lack of prejudice?
Because in 2010, after she filed her contempt order, they had an agreement that if he continued working for another 7 years, he could have retired right then. Under the MSA, he had not just the power, he had the contractual right to retire. Both parties agreed he was going to retire at either 65 or 66. He worked an additional 7 years in Japan, dragged his family over there, worked 7 years to continue paying these monthly alimony payments. And because he believed, I think fairly, that she had agreed to waive her right to the remaining, whatever was remaining on the 2003 MSA. So I think that's why he changed his position.
Considering that the dispositive factor, is that not weighing the evidence in our position?
Is what the dispositive factor? Sorry, Your Honor.
If we, overlook the fact that he was able to pay off a mortgage and he was able to pay off this IRS bill and had to work for 7 more years, are we weighing the evidence in that situation as to whether or not he was prejudiced for the purpose of latches? Or is it, as a matter of law, if he goes and works 7 more years in Japan, that's not prejudice? That's what I'm struggling with here. That makes sense.
Yeah, I think so, but I think we're weighing evidence that the court didn't address. Obviously she heard, but yeah, I suppose that's weighing evidence.
Well, determining whether there's competent substantial evidence. So in other words, for us to say that the evidence that he paid off his mortgage and he paid off his VIP, or he paid off his tax bill, is not competent substantial evidence that there was no prejudice. Wouldn't we then have to say that because, as a matter of law, this working additional 7 years in Japan was what prejudiced him?
I would argue we have a waiver argument too, and I think that's competent substantial evidence that there was a waiver, that there was an agreement and a valid waiver defense, and that's why he did what he did. And again, I mean, this isn't. Your honors have seen enough divorce cases. I realize I'm in my rebuttal time, so I'll go ahead and reserve. Sorry for running over.
That's fine. All right. Counsel for the FLE.
Thank you, Your Honor. Jim, I apologize. I have Scott Wiederman along with me that's listening in, but will not be participating in today's hearing. Thank you for having us today. Thank you for right out of the gate bringing up the competent substantial evidence standard of review, because that was important for this case, especially as it comes to latches. So we're discussing this latches situation, but we're missing some of the points. There's a lot of defenses to latches, all of which we've brought up within our briefs. Unclean hands, as we've been discussing.
But not that was not a factual issue that was played out in the trial court, correct?
That's correct. It was just brought up in testimony, but it was not an issue that was brought. The burden of proof is, of course, on the appellant and the court to bring this latches argument and to bring substantial competent evidence, which is not before the court.
Right. So with the lack of factual findings of an example, unclean hands or a lie or example, shouldn't we then constrain our review at this level to whether there's competent substantial evidence supporting the court's determination that it was not barred by latches or not barred by waiver in the first instance, regardless of defenses to those?
I would say no.
Their avoidance.
I'm sorry. I would say no at that argument because the trial court did entertain and did hear the testimony on those issues. Did hear the former husband discuss that? Yeah, I did mislead on my income. Heard the testimony of the former wife that said he was destitute. I've got 5 grandchildren. What am I supposed to do? Put them on the street? To the point where the former wife had said, I'm going to loan him money because I feel bad for him because he's so destitute. I'm going to actually loan him money. The fact that he's not paying me, even though he's bringing in $250,000 a year in income, I'm going to loan him $12,000. That's her feeling at the time. Latches is not just about time, Your Honor. Latches is, and I'll quote, and we did quote this in our statement, latches is a defense requiring proof of due diligence by the party against whom the defense is asserted and prejudice to the party asserting the defense.
Right. And so those considerations might be relevant to prejudice and or to the prejudice component, for example. But but making a factual finding at this level of unclean hands might be inappropriate still.
Again, it would be a permissible inference because the former husband even acknowledges within their own brief that, yeah, we kind of lied about our income during this period of
And I
time.
think when we look at permissible inferences, though, aren't we looking about it whether it supports a trial court's decision, not whether we can make an inference to find a fact?
That's
We're
correct.
looking at so without a decision on unclean hands, how are we as an appellate court supposed to consider that defense?
Well, Your Honor, the trial court did consider this issue. This was an affirmative defense.
Was
that
there a
brought
finding
before
on
the
it,
court.
though? Was there a finding on unclean hands?
That's not specifically mentioned, but if you go through the order, it specifically says that the court, having considered all factors, including the credibility of the witnesses, that is to me the key phrase of the court order. The court heard the testimony, understood that we have a deception going on here. I'm going to tell you I'm making nothing, but I'm really making a lot of money. The wife acknowledges, yeah, I believed them. And as a result, that's excusable neglect. And that's where we get into. So unclean hands is certainly the deception that was in there saying that I'm not making any money. The deception about the tax levy, and you're correct in bringing up the tax levy situation. That does appear in the transcript on on the third day, page 402, I believe. And he told them that the money had been levied upon. These are falsehoods. You can't come into the court of equity and ask for these type of relief. It specifically says, he who acted in bad faith, resorted to trickery or deception, or being guilty of fraud, injustice, or unfairness will appeal in vain to a court of conscience, even though in his wrongdoing he may have.
Can you address appellant's argument that there's no confident substantial evidence of prejudice as it relates to Latches, because this was all brought to light well before this action was filed, and he agreed that he was going to work 7 years in Japan and make it right?
Sure. Well, I'll address the last part of that first. The 7 year, I'm going to work longer. That was never a deal between the parties, so that in the context in which they're using it. The agreement between the parties is that he had to pay his income, a percentage of his income, as long as he worked. There doesn't say he pays a percentage of his income until he's 65. So as long as he continued to work for whatever reason it is, she was going to get the money. So to make a deal that she was going to get the money if he continued working, she was already going to get that money. So there's no benefit of a bargain. There's no.
Wasn't the alleged deal that he would continue working?
The alleged deal is that he would continue to work, but again, the former wife would already get that money. I
don't think that's the issue. The issue isn't whether if he worked, would she get the money. The issue is, would he continue working when he didn't have to?
Okay. And again, It goes back to this deception that was going on where I don't have any money. I have to continue to work so that I'm not homeless. I need to borrow money from you so that I'm not homeless. And that is the deception that's going on here. Again,
Counsel, before we continue into this seems like the biggest issue in the case. But there's one issue that's sort of bothering me. I'd like to just deal with it, and then we can come back to this.
Yes, sir.
The $11,000 credit for the VIP account. Maybe I'm misremembering, but I don't remember you addressing that argument at all in your brief. Am I just misremembering? And if either way, could you address it?
I would, and I think we're talking about what they deem to be the mathematical error of the trial court. Is that
the $11,000 credit for monies repaid on the VIP account issue?
Correct. And the trial court had asked. Actually, it wasn't in the trial court. It was former husband's own counsel asked him, "Do you want credit for any of these payments that were made?"
Right. That VIP account issue, I don't think was included in that.
Again, I think
I read it in the record. I didn't read it that way.
Okay. To me, I took it as
you want to point me to a place in the record that maybe I missed?
If you give me just one moment, I may have it right in front of me.
He did say that, but it wasn't. I didn't read it as referencing the VIP account at all. It was other issues like retroactive alimony and things.
Okay, the trial transcript, volume 3, page 437. Appellant admits, counsel for the former husband asked this is in the initial brief, asked if former husband is seeking credit for the amounts paid in alimony after the filing of the petition, and former husband responded no. Again, so that to me, that encompasses all alimony.
Counsel, you just said alimony. We're talking about the VIP account.
Right.
Credit for the VIP account, which was a retirement account, right? Was a VIP account a retirement account?
Yes, it was.
Oh, okay. So that's not alimony, is it?
It is in the context of how it was paid out. That was all part of the alimony agreement that was made. This is how alimony is paid out. It's going to be paid out, some from this account, some from this account. That's how that was.
So alimony was going to be paid out of the retirement account?
Part of the alimony in 2003, the whole deal to resolve this case, Your Honor, what we're saying is you've got an amount of money that's going to be paid from husband to wife over time. And that could conceivably be looked at as alimony, as a general blanket. And that's how I read that context.
The VIP account wasn't distributed as a marital asset. It was being distributed as an alimony payment.
That's unclear. All it's saying is in the order itself. And again, I've got the actual.
Well, if it's not alimony, then that statement that you read in the testimony wouldn't apply. You agree?
I agree. If it's not alimony, yes.
Can you give me a clear explanation as to how the retirement account was alimony? I'm just not following. I'm sorry.
Okay, I'm looking at it just more of a global sense, looking at it as a whole. If you look at it as a specific, I don't think that it's marked out and divided out in the original 2000.
I mean, wouldn't a retirement account usually be distributed as a marital asset? And it seems foreign to think of it as, oh, well, here's this marital retirement account, and we're going to count it as alimony. I've never seen that.
And I would agree with that, Your Honor. But I think that when the court had asked, do you want credit for any of that? I think it was generally answered no, and that's where the trial court based its decision.
Well, on this $11,000 credit for the VIP account, is that your only argument on that issue? That it was waived at trial?
Waived at which trial? I'm saying the 2019 trial.
You just said that it was waived in the testimony at trial, right? He said, I'm not seeking repayment for alimony.
That's correct.
Is that your only argument on this $11,000 credit for the VIP account?
Just as to the $11,000 solely, yes. I think that is a correct statement.
Okay.
So to go back into this Latches argument, the Supreme Court's been very clear that a recipient may rely on the truth of a representation, even though its falsity could have been ascertained had they made an investigation, unless he knows the representation to be false or the falsity to be obvious. Here we've got very clear. Wife didn't know that he wasn't destitute. She's loaning him $12,000.
I think that Judge Sasso's question was more related to, when the trial court hasn't made a specific factual finding, how does that affect our review for substantial competent evidence?
I think you're going to rely on the trial court in the decisions they made. They've heard arguments on all of the issues presented, whether it be waiver, latches, ambiguity, mathematical errors. The court. In
other words, your position is, look, if the trial court was silent or vague as to its reason for denying the Latches defense, then your position is this court should look for any substantial competent evidence in the record that would have supported it, whether it be on unclean hands or prejudice or whatever other grounds.
That's exactly right, because the court, by not identifying specifically, that means that it could have been a combination of all. It could have been a combination of all the arguments, that it's not only unclean hands, it's that the.
I guess Judge Sasso's probably question. It's an astute question, right? Because, I mean, could a finder of fact look at this evidence on the unclean hands issue. And could a trier of fact conclude, well, no, there's no unclean hands here. And so I guess, she's saying, look, if this could go either way, should unclean hands be an issue that this court, sort of takes up and affirms on?
Understood. And again, but it doesn't necessarily need to be unclean hands. It could be unjust enrichment. Unjust enrichment are latches certainly could not be available to those who are unjustly enriched by it. Smith case that I cited within our motion. We got the appellant admits he withdrew $160,000 from the VIP account used to pay off his mortgage. That confers a benefit on him. He admits he made expensive purchases. That confers a benefit on him. He actually turns around and then argues, well, I'm going to be prejudiced because I'm going to have to pay interest. Well, he also saved interest on his mortgage by using wife's money to pay off his mortgage and to make these expensive purchases, where if he didn't have the money, he would have put them on a credit card. He would have paid those interests anyways. There is an unjust enrichment that is very clear in the testimony of all the parties, very clear in the record, brought up by both parties within the briefs, that there is husband being unjustly enriched. He used wife's money to make purchases and to pay off a mortgage. That's clear unjust enrichment on the part of the husband. And it's also clear prejudice to the wife, because it was the wife's money that was being used. The wife doesn't own former husband's house. She doesn't own the goods that he purchased. These are the prejudice. Wife could have used that money. Wife could have retired earlier. Wife is still working these days. Why? To pay attorney fees to chase the money that husband never paid her. These are prejudices.
Counsel, be that as it may, counsel for appellant is saying, take everything you say is true. Wife knew about this long ago and sat on her rights. I mean, that's what Latches is all about.
Absolutely, Your Honor.
Judge Sasso has asked you, and I'm asking you now, what evidence is there that she didn't have sufficient information to go forward, whether it was in 2010 or 2011, whenever it was?
Understood. And the testimony is clear within the record and cited within our briefs that husband had told of being destitute, let's use that word. And she relied, and she's allowed to rely under Florida law on that information to the extent that she herself went without. You know something? I don't want to put you on the street. We have 5 grandkids. In fact, I'll even loan you some of the money that I have coming in. That's the evidence before the court that says that she reacted in the testimony before the court was very clear. Husband didn't tell the truth. Wife relied on that truth through that whole period of time. 2010, she started, you know something? Something's going on here, a little funky. So she makes hires an attorney, pays the money, goes before the court with a motion to compel. There's a deposition. They end up making a deal. The deal is, I'm really destitute. Don't do this to me. You're going to put me on the street. So she holds off. He's supposed to make more payment. He doesn't make those payments. This lie just continues until such time that she says, you know something, I'm being had here. And that's when she proceeds in 2017. 2017, 2018, she files a number of motions. Those motions aren't heard until 2019. That trial does not get a resulting order for a year. That comes out in 2020. Now we're in 2021 with the appeal of that order. So she did act reasonably because she reasonably relied on what she was being told. And that's, I don't have any money. Why would my client spend money, time, effort chasing an empty bank account? That's what she believed that she had. When she started figuring out, no, something's going on, I think he's being deceitful to me, she acted promptly. But the courts have been very clear. It's not the passage of time with Latches. It's the passage of time and an unreasonable delay in enforcing a right. It's not unreasonable not to pursue someone who doesn't have any money. Courts are expensive. Attorneys are expensive. And to spend good money to chase bad money, it didn't make any sense. Our client has made that decision when she ultimately figured that, no, I think I've been had here. And that's what she did. And those were the motions that were brought before the court. And those were the arguments that were presented to the court by both parties. Both parties had every opportunity to present whatever evidence that they wanted, make whatever arguments they needed to make. They had the opportunity to rehabilitate their witness when he says, I don't want any credits for these monies. They didn't do that. So here we are with a judgment that comes down and says, nope, I'm gonna find the way I do. It doesn't specifically say unclean hands, it doesn't need to. It could be based on any of the arguments. And to me, it's an accumulation of all of the arguments that she made. And this court sitting with in the seats that it is with competent substantial evidence, just has to look and say, was there any competent substantial evidence that the court could have used as a basis? And the answer is yes, of course. Husband admits, yeah, I deceived her on money. Yeah, I didn't pay the $168,000 that I owed. So that's where we are today. Again, this is wife 18 years later, still just trying to get her money. Husband using wife's money throughout through his life. So I think that there is competent, substantial evidence that the trial court relied upon, and that this court can look back on and say, yep, it could be any of those issues. It's not one specific pigeonhole, unclean hands. It could be unjust enrichment. It could be lack of prejudice. It could be any of those issues, or it could be a combination of all of those issues. But the court heard the testimony of the parties, determined the veracity of the party for the truth of it, the credibility of the witnesses, as they call it in the order, and they determined that, yeah, husband's not someone that we can trust. Someone that wife could trust. She had a long-standing relationship with them, had 5 grandchildren with them, but he misused that trust. And with Latches, as long as they acted in bad faith, or there was fraud or injustice or unfairness, those are all ors. It could be any of those. Then the trial court was correct in denying Latches. And we ask the same of this court, that they find that the trial court reasonably relied on the testimony before it. And I see that my time is up. So if there's any other questions.
I don't think so. We're going to go on back to Mr. Brownlee for the rebuttal.
Your Honors, the timing and the testimony in this case is dispositive. On trial transcript pages 75 and 158, former wife testifies that as far back as 2008 and 2009, she was suspicious of of former husband's representation of his financial status because of his gross earnings, again, not net, in 2008 and 2009. She files her contempt motion in 2010. Doesn't say anything about variable alimony, takes his deposition when she's represented by counsel, and takes no further action. 7 years later, she presents the exact same arguments, and there is absolutely nothing that she learned in that time that would have prevented her from making the same argument she made a decade earlier. Not to mention
she's saying, giving you total credit for that knowledge and time frame. She's going, geez, he has all this money, yet he's claiming he has none. That's exactly what he told the trial judge here. Yeah, I got $4 million. I don't know where it all went. I have no clue. All I got left out of $4 million is $220,000. So he was basically telling her the same thing he's saying now, which could have been true.
Your Honor, all I know is we're talking about unclean hands. That is a specific affirmative defense you plead in avoidance that was never pled as a reply to the Latches defense. Unclean hands was never even mentioned anywhere in the trial proceedings. So for this court to go in and say, hey, it looks like there might be some evidence of unclean hands, that is not the function of this court. To me, that would be tantamount to saying, in response to a statute of limitations argument, the other side never mentioning, hey, there could have been some tolling event we didn't discover, the statute should have accrued at that point. Please, appellate court, go back in the record and look. There's something that could excuse the reason we didn't bring suit when we did. That's not how this works.
Tell me again where the prejudice is. Tell me where the prejudice is to your client for her waiting.
The prejudice is that he worked an additional 7 years that he didn't have to. He could have filed to either reduce or terminate his alimony obligation. The prejudice is that she could have done all of this in a quadro in 2003. The prejudice is now he has to pay it in a lump sum payment and he has over $120,000 in interest. And there are about 3 cases we've cited in the briefs. Mason versus Mason is one of them, that all speak to being interest and lump sum payments being sufficient evidence of prejudice. With that, I think we're probably beating a dead horse. If your honors have any other questions, I'd be happy to answer them. But I think that's all I have to say on rebuttal.
I don't see my colleagues chomping at the bit for another question. So with that, we will be adjourned. Thank